Megan?
Hello, everyone. I know that those of us in the Berkshires have just gone through a pretty wild thunderstorm, and some of you may have your power off. Just a reminder that we will be sending the recording of today's program to everyone who registered, and you should probably be getting that tomorrow. So if your power goes out, it's not already out, but it does go out, anything like that, we will be sending you that link. And in fact, our esteemed moderator today, his power is out, and he is using the batteries on his computer and also a battery-powered Wi-Fi hotspot, which I just added to my shopping list because I didn't even know they had them. So I know folks are still coming in, but I'll start my introductions because we have a lot of interesting things to talk about today. My name is Megan Wilden, and I am honored to be the Executive Director of OLLI, the Osher Lifelong Learning Institute at Berkshire Community College. We provide educational, social, and volunteer opportunities designed especially by and for people 50 years and better, but are open to everybody. I am delighted to welcome not only many OLLI at BCC members, at least those who still have power and access to the internet, but also members of other OLLIs from around the country, including from Hawaii, California, New Hampshire, Michigan, Washington, North and South Carolina, Pennsylvania, South Dakota, Virginia, and more. Thank you for joining us today. I know we all share a love of learning and interest in all the different aspects of our world today, and I think this program will be very enlightening and interesting for all of us. One of the most extraordinary things about OLLI at BCC is that our programming is almost all developed and organized and often taught by our members themselves, and that is absolutely true about tonight's program. Doug Mishkin is he is an OLLI member. He's an OLLI instructor who has taught 2 classes for us that were rapturously received. One of them was on the Scopes monkey trial, and the other one was on folk music after Woody Guthrie. So he also has a wide range of interests and shares them with us, which is great. Doug now practices poverty law in Western Massachusetts after practicing in Washington, D.C. for many years. He's a graduate of Brown University and the George Washington University Law School. He has litigated landmark civil rights cases for various organizations and is also proud to have taught for OLLI. He's won a bunch of awards, but Doug assures me that they are all meaningless. He told me to stop this introduction here so we can get to the good stuff. I just want to say, however, that so what happened was Doug called me up and said, you know, I would really love to put together a program on Zoom and bring, you know, some amazing lawyers together to talk about these really important cases that were decided this summer. And I said, yes, of course. So here we are today. So please join me in welcoming Doug Mishkin. Doug?
Thank you, Megan. And you'll remember to enable my share screen capability. Welcome, everybody. I am Doug Mishkin. Don't adjust your screen. This is what I look like when I'm in my home office with no power in the house. I have yet to participate in any program where I heard someone say afterward, I wish the introduction had been longer. So in that spirit, let me dig in. Within 12 days, in June and July of 2020, the Supreme Court decided 3 significant cases involving the relationship between government and religion. May a state forbid tax-supported scholarships to religious private schools? Are private religious schools exempt from anti-discrimination laws in employing teachers with religious responsibilities? And must organizations with religious objections to contraceptive insurance coverage under the Affordable Care Act give notice that they won't provide that coverage if, as a result of giving that notice, the coverage would then be provided another way? How would you answer those questions. Have strong feelings about these issues? That's easy. Thoughtful analysis comes harder. We're here to help. More specifically, our two experts tonight are here to help. Walter Weber is Senior Counsel for the American Center for Law and Justice in Washington, D.C. He's a graduate of Princeton University and Yale Law School. Richard Katsee is Legal Director at Americans United for Separation of Church and State in Washington, D.C. He's a graduate of the University of Michigan. He received a master's in political science from Harvard before graduating from Yale Law School. Who knew Yale had a law school? Walter and Richard both specialize in First Amendment appellate litigation. Their organizations filed amicus briefs, friend of the court briefs, in the three cases we'll discuss. I'm delighted to welcome them both. I plead guilty. I called Megan. I said, I thought this would be a wonderful program. Really, it's just my way of getting to educate and entertain myself by hearing from these two experts. I'm delighted that many of you want to join in. For each case, you will hear what was the case about, what did the Supreme Court decide, and then what do Walter and Richard have to say about each case. You'll see that they have markedly different views. Now, with the number of you who registered or are actively participating at this moment, all I can say is I'll do my best to take a look at your chat questions toward the end, but I make no promises. As they say, let's get down to cases. Walter's going to get us started with Espinoza versus Montana Department of Revenue. May a state forbid tax-supported scholarships to religious private schools? Walter?
Sure thing. Thank you, Doug. To understand this case, it's important to understand a case that came before it, and that's a 2017 case called Trinity Lutheran Church versus Comer. And just briefly, that was a case where a state had a program that would use recycled tire rubber to resurface playground surfaces. So in other words, make the playground safer. Instead of kids falling on gravel or something that would give them splinters, instead they fall on kind of a rubbery soft surface. And a school playground that was basically owned by a church applied for the grant, was told, well, you're not eligible because under our state constitution, we have a no aid clause that forbids us from giving any money to churches. They challenged it in court. It went to the Supreme Court, and the Supreme Court by a 7-2 vote said that it violated the free exercise clause to deny the church access to this grant program to which they were otherwise eligible, qualified, and so forth, just because they were religious. The status exclusion violated the free exercise clause. Okay, now that involved safety for kids in a playground. Fairly non-controversial. All the sympathy was on the side, generally, I think, of the school seeking the grant. The new case, the Espinoza case, goes to what has been historically a very divisive area of constitutional litigation, which is namely, what do you do with the religious schools who are trying to get access to some sort of a program that the government has set up to provide assistance? Now in Montana, where the Espinoza case came from, the program was essentially of tax credits for donations to scholarships. You've got money, you want to support needy kids who want to go to a private school, you donate to a scholarship fund. The scholarship fund in turn accepts applications from the parents. If the parents are approved, they tell the scholarship foundation, well, we're going to go to school X, whatever it is, and then the scholarship foundation sends the money to that school. So there's an argument that this is really very indirect. There's not government money, it's government money not being taken from because they're getting a tax credit. It's the parents who are making the choice. It's a private scholarship organization. It's donating the money. All right, leave that aside. Lots of states have things in their state constitution called no aid clauses, and they've been read, frankly, very differently from state to state. Some of them are very strict in their interpretation, and some are very relatively lax. Montana apparently falls into the strict category. So what happened was, after this program was adopted, a state agency said, well, you can't use this at a religious school because we've got the state constitutional provision. Two or three parents sued saying, well, we want to send our kids to private schools. They are religious schools. The Scholarship Foundation is willing to give us the money to go there because we qualify as being people of either low means or children with disabilities. And we think this rule is not proper to bar us from going there. Well, the state trial court struck the rule down, said, that's right, this rule is not proper. Parents, you're allowed to use the scholarship money at the religious schools. The government appealed, and on appeal, the state Supreme Court said, whoa, wait a minute. We agree that this rule wasn't proper, but the whole program has to be tossed out because we have this no aid clause. And in our view, the no aid clause applies to money that is channeled, however indirectly, through the scholarship program. And in fact, the Montana no aid clause was even amended to add the word indirect or indirectly in it. So the parents, having lost at the state Supreme Court level, appealed to the US Supreme Court, saying this violates our right to free exercise rights. We're being excluded exclusively because we want to send our kids to a religious school. Supreme Court granted review and by a 5-4 vote said, yes, this does violate the free exercise clause. We take it, this is what the US Supreme Court said, we take it as a given that the Montana Supreme Court has the ultimate word on what its constitution means. And if it says that its no aid clause bars tax credits that go to support a program that may include religious schools, then we're bound by that. However, we are not bound by their interpretation of the federal constitution, of course, and we rule that because this program singles out religious schools because of their status as religious schools, that it falls under the same rule that we used in the playground case, Trinity Lutheran, namely, you are disqualifying otherwise eligible entities solely because of their religious status. Side note, the status question could potentially be important in the future, and it certainly reflects on things that have gone in the past. Status as opposed to use. There's a history in Supreme Court cases of saying, yes, the government can restrict the use of government funds so that they're not used for religious purposes. But the Supreme Court said this is on the status side of that line. Now, there are people who've challenged the difference between status and use, and so you can't really distinguish between the two. The Supreme Court didn't resolve that. They said, we view this as a status case. Otherwise, eligible entities are being excluded solely because they're religious. That violates the free exercise clause. We reverse, send the case back down. Victory for the parents. Now, Doug said, well, he wants us to say our view on whether the decision was good or bad. My view, and again, we filed on the side of the parents, is it's right for three main reasons. First, it's a victory for school choice and parents' rights. Every parent wants to be able to send their kids to the school that's best suited for their child's education. One size fits all doesn't fit all. And sometimes the public schools just don't have whatever it is that the parents are looking for in the program. The scholarship program set up in Montana enables parents to exercise their choice, assuming they get the scholarships, to go to the place that they think is best suited for their kids. And the parents in this case testified about how they thought these schools were especially helpful for their children. And I should note in terms of the school choice that schools have historically been a source of a lot of controversy, whether it was school prayer, teaching evolution, sex ed, current transgenderism issues, whether you teach a pro-America patriotism version of history or a Zin version of America has been historically an oppressor. All these issues, even fighting over PE clothes, if you can believe it, have been gone into the courts or certainly into the public square. And in my view, a great solution to that is let the parents pick what they want. Rather than say, we're going to fight over what the public school is going to teach, let them say where they want their kids to go. Second reason I think the decision was right is because it upholds the principle of non-discrimination against religion. Free exercise clause is guaranteed in the Constitution. If it means anything, you'd think it would mean at least that you can't be targeted because you are religious, and that's what the Supreme Court said. And then finally, I think it is especially important that people have freedom of choice when we have an ever-expanding government. And right now we have a situation where, obviously we've got a bloated federal budget and the things the federal government can regulate, and the state governments for that matter as well, are always increasing. And so the more parents can say, or for that matter, any citizens can say, well, all right, the government's getting so big, I want to have some space for me to pursue the view for my life, my family, that I want to pursue. And in that respect is also a good decision. Back to you, Doug.
Richard, I suspect you have a different perspective on this.
Yeah, absolutely. So first of all, look, thank you for having me here. I'm so pleased to be doing this, and I love the audience and these programs. I also wanted to say Walter did a great job of really carefully going through and talking about how the case came up and what it dealt with before getting to his own views on it. So I want to take issue with why he's presented as it's a good decision. One of the things that Walter said is he thinks it's important to let parents decide where to send their kids to school. That's true. That's absolutely true. But that's not what the case is about. The case is about who pays for that schooling. What's unprecedented about this decision is that the court was saying not even just that the state could pay for tuition at religious schools, but that it had to do that if it was funding schooling at secular private schools. We've always understood, and Walter said this, we've always understood before that that this was a different context. Schools aren't something, religious schools aren't something that the government funds. And the reason that it doesn't fund it is not hostility to religion, not disinterest in or hostility toward parent choice, but the recognition that we all should get to decide whether and how our money does or doesn't support religion and religious instruction. And when the court says, well, gee, you've got to pay for the tuition at this religious schooling, that cuts very much against the grain. That said, there are some things that the court didn't speak to, and I want to point those out and why they're important. First, it's absolutely right that the court didn't decide the question whether states can say we're not going to allow money to go to public money to go to religious uses. Things like Bible classes or chapel services, stuff like that. The state may not be able to say we're not going to allow money to go to tuition at religious schools, but they might still be able to say that money can't be used to support actual religious activities. I think that's really important because that gets to an incursion on the religious freedom for all of us to make those choices for ourselves. The decision also doesn't address whether states have to fund religious schools that discriminate in their admissions or their employment on things like race, religion, sex, sexual orientation, gender identity, disability, the whole panoply of basic anti-discrimination protections. And it turns out that most religious schools, 12 of the 13 that would get money in Montana, do discriminate in their admissions. Now, schools very often exclude LGBT students or students with disabilities, or they require that you and your family be a member of their church and live according to their religious requirements, or you can't go there. One of the things that then matters is, again, not that schools decide that that's what they want to do, and not that parents decide that's the instruction that they want for their kids, but what are the rest of us paying for? Do we have to pay for schools that wouldn't accept us or our kids for reasons that have nothing at all to do with religion, but are just what would in other contexts be ordinary discrimination? Again, the schools get to do it, but should the rest of us be paying for it? The other thing I should say, the last thing I want to say at this moment is that the decision also didn't say that states have to subsidize private education at all. They can reserve public funds for public schools, and lots of states do in their constitutions or in their laws. They say that if you have public education dollars, those have to go to the schools that serve everybody. I think that that's a good thing. And I think that the reason for preserving the separation of religion and government, and the reason for wanting to keep religion and religious instruction out of the public schools is so that those schools remain open to everyone. And when government starts funding things that are selective and that exclude people, I think that something has gone badly wrong. What's supposed to be a collective use of money for a collective good is no longer serving us all. It's serving those with political power, or it's serving those who maybe already have the money to begin with, or it's subsidizing choices that exclude a lot of us. And as I said, I think that something has gone wrong when the government is doing that. And those are all, though they're open questions, they're ones that that are implicated and are worrisome consequences coming out of the Espinoza against Montana decision.
So let's take some of the time that we have left for this case, and I'd like to hear the two of you chat with each other about the points each of you has made. Walter, if you want to pick up where Richard left off, what would you like to ask him, tell him, take it from there, and let's do a few minutes of conversation. I've got a couple of questions of my own for each of you, but we won't indulge me yet.
Yeah, let me start with a point that Richard. First, I want to thank Richard for his very thoughtful response, and I want to pick up on a point that he alluded to, which is what do you do when you've got government money with strings, right? And Richard was saying you may have a school that's a recipient of some assistance program that has policies that the government doesn't like, some discriminating on some basis that otherwise would not be allowed. And I got to say, that's actually a very good argument that groups like Americans United for Separation of Church and State have made over the years, which is when you've got money, you've got the potential for corrosion to come with the strings, right? Once you're on the dole, then there's going to be a pressure for the government, for the private body, to conform to the government's wishes to keep the money flowing. I think that is a legitimate and very serious concern. My best solution to it is to say that the government should structure its programs. If it's going to do that, it should structure its programs in a way that maximizes detachment from the private entity. I mean, the playground resurfacing case also went to a church that presumably didn't allow non-believers into its church, and there will be police, fire, assistance, all these things that the government provides to everybody. It doesn't say you're not eligible because you have a position on marriages being between a man and a woman that we disagree with, or vice versa. And so one of the nice things about the Montana program is that it was so indirect, so attenuated, in that you don't have the government telling the school anything other than it's got to be a qualified educational agency or entity. And I think that bar was very low. So there's always going to be the question, not just in this context, but generally, if the state is going to say you have to educate your kids, then how is the government going to make sure that the education the kids are getting is genuine and not inadequate or neglectful, without being the nanny over the parent's shoulder all the time? And that, in the religion context, it's in my view the same issue, only perhaps magnitude multiplied by the concerns about intrusion into religious matters. I don't want to overwhelm all the points at once. I'll hand it back to Richard if he wants to take over that.
Yeah, I do. Thank you. Although one thing, I haven't been watching the chat really, but something just caught my eye. Someone asked about the difference between use and status, and it's worth taking a step back and saying a bit about that. The idea that when the Supreme Court has drawn that line is status is you are a person or an institution that is religious, and use is the money spent on religion. That's kind of the difference. And so the idea is you can't say you're not eligible for a government grant just because you are religious. You should be treated like everybody else. But in treating everybody the same, saying the money can't go to religious uses, can't be spent on religious stuff, because that's not what government is supposed to be taking sides on. That's kind of where the division is. Now, to respond to what Walter said, so you started with the focusing on how government money comes with strings, and your proposal, your analysis was that we should minimize those as much as possible, so that government isn't interfering with religion. And by the way, the basis for the separation of religion and government traces back not just to political theory, but to theology, and particularly the theology of Roger Williams, the Baptist theologian who founded Rhode Island, who said this: if government is supporting religion, even giving money and helping supporting religion, it is taking sides. It's kind of stacking the deck in favor of certain religious beliefs rather than others. And that means that means two things. For those of us who are trying to figure out what we should believe in and how we should, whether or how we should practice a faith, the government goodies might be stacking the deck and making some things seem more appealing than others, not because of their innate goodness or correctness, but because the government has determined that this is the thing to be favored. And the other thing that Roger Williams said is that churches and religious denominations, when there's money at stake, might distort their own beliefs, maybe subtly, maybe not intentionally, to try to appeal to the government to get that money, and that's dangerous to the religious freedom of the institutions. Those are the things that the separation of religion and government is supposed to protect. And the flip side of that, in saying, well, then give money but without strings attached, is that if government is being responsible in the way that it spends public money, there are supposed to be strings attached. The government is supposed to be making sure that you're doing with the money what it gave the money for, that you're being responsible with it, that you're not squandering public assets. So those two things don't fit well together. If the government is giving money to religion, either it has to exercise control, being a good steward of money, but making an incursion on the religious freedom of the institutions, or it just gives a free hand, in which case it's not being a good governing entity. It's not being responsible. The way to avoid that is the separation.
Doug, may I?
Gentlemen, let me exercise the prerogative of the moderator, because I'm looking at the clock and we have 2 more cases to go. But exercising that prerogative, I do want to pose one final question that arises from this case, and throw it open to each of you if we can do it briefly, which is because I want our audience to get introduced to the term play in the joints. Right, that the expression that's used in this area of the law is that there is play in the joints between the Establishment Clause, Congress shall make no law respecting an establishment of provision, establishment of religion, and the Free Exercise Clause. Right, and I'd like each of you, in a minute or so, to give our audience a quick understanding of what are we talking about when we talk about play in the joints between those clauses. Walter, you want to take a first crack?
Okay, I'll try to give a 2-sentence version. The play in the joints concept basically means that not everything that's forbidden by the Establishment Clause is required by the Free Exercise Clause, and vice versa. In other words, there's a space in between those clauses where the government has the freedom to act. And that is to avoid having the 2 clauses basically be in hammerlock conflict with each other.
Richard?
And the one very small point that I'll add to that is the idea is supposed to be then that government can take steps to promote either of those sets of values, either the ones protected by the Establishment Clause or the ones protected by the Free Exercise Clause. And by the way, a lot of the time they overlap. They point in exactly the same direction. But to promote a greater separation than is strictly required, or to accommodate more religious exercise, give it some sort of additional special treatment than is absolutely required. And so that's the idea, is there's that space where you can do one or the other of those things.
So let's give our audience an example of what we're talking about.
RFRA, the federal statute that protects religion, was passed because the Supreme Court had held that the Free Exercise Clause did not require any heightened judicial scrutiny against laws that applied to everybody, but had the consequence of restricting a person's religious freedom. You know,
okay, RFRA being the Religious Freedom Restoration
Religious
Act.
Freedom Restoration, a federal law which was not required by the Constitution, but was permitted by the Constitution to enhance free exercise protection.
And on the other side, an example that I would give, although we're not sure exactly what they mean anymore, are the state constitutional provisions that require a greater separation of religion and government than the federal First Amendment does, saying even if we could indirectly fund certain sorts of religious education or religious or religious entities, we the state are not going to do it, because we think that there are good reasons that religious freedom is better promoted by not.
All right, I suspect we'll be coming back to play in the joints in a later discussion, but time's a-wasting, and we're on to case number 2, Our Lady of Guadalupe School versus Morrissey-Berru, decided July 8, 2020. Are private religious schools exempt from anti-discrimination laws in employing teachers with religious responsibilities? Richard, want to set up the case for us?
Yep, and I will try to be as pithy as Walter was. So there were actually 2 cases here about 2 fifth grade teachers, both at Catholic schools in California, different schools, who were fired from their jobs. They were both lay teachers. They weren't nuns. They weren't ordained. And let me tell you about them. Kristen Beal had been a substitute just starting her career, and they liked her, so they hired her full-time to teach 5th grade. Reading, math, all the usual subjects, right? She'd take the class down the hall for mass when the school had it and make sure that the kids weren't disruptive, but she didn't lead prayers, she didn't select the liturgy, she didn't have any special religious training, and the school didn't require that she be Catholic. She had good, positive reviews, and then she was diagnosed with breast cancer, and the school got rid of her. She's actually died since. The other teacher, Agnes Morrissey-Berru, was an experienced teacher who she too taught all the regular 5th grade subjects, but she also led daily classroom prayers. She taught a religion class basically out of a workbook once a week, and she planned the school's mass and chose the liturgy once a month. She'd been teaching at the school for about 16 years, and everybody loved her. Then she turned 64, and they fired her. Now, the teachers both sued for employment discrimination. Beal, that's the teacher with breast cancer, sued under the Federal Americans with Disabilities Act, and Morrissey-Berru sued under the Federal Age Discrimination in Employment Act. Federal law, as many of you will know, also bars employment discrimination based on race, sex, and religion. Now, the schools in both of these cases defended the lawsuits by invoking something called the ministerial exception. This is a judge-created legal doctrine under the First Amendment that says religious institutions are exempt from anti-discrimination laws when it comes to hiring and firing their clergy. The idea is this: houses of worship are and ought to be free to determine their theology and how they propound it. Clergy are the folks who develop religious doctrine and decide how it's to be taught. So if you're really going to be free to decide what your church doctrine is, you also have to be free to pick and choose your clergy. Call it instrumental to pursuing your religious mission. What's interesting about the ministerial exception is that it doesn't apply just to religious judgments about who to hire and fire. It applies to all employment decisions. We, as a religious institution, can fire you because we could pay a younger teacher less who's coming right out of college. That's Agnes Morrissey-Berru, or that's what she alleged. We can fire you because you might take some sick days that'll require us to pay a sub. That's Kristen Beal's case. Now, the laws against employment discrimination already exempt religious employers from the bar on religious discrimination. If you aren't a member of our denomination, we don't have to hire you to work at the church. That's legal, and it applies for all employees, the janitor as well as the pastor. So this ministerial exception is really interesting because it actually comes into play only when people are hired or fired for non-religious reasons. The church says, we don't want a Black pastor. We don't have a religious reason. We just don't feel comfortable around Black people. The sort of thing that just wouldn't fly in any other context. But that's where the ministerial exception comes in and says, well, you get to do that. The Supreme Court recognized this exception, this doctrine in 2012. These cases were about figuring out who counts as a minister, who doesn't get the legal workplace protections, which employees do and which don't. A majority of the Supreme Court held that both the teachers I told you about, Beal and Morrissey-Berru, counted as ministers, so they couldn't sue over being fired. The court didn't give a terribly clear test for figuring out whether or when lay people count as ministers. What it basically said is courts should look at what an employee does. Does that employee have, let's call it, meaningful religious duties or not? If so, the person counts as a minister and isn't protected by the anti-discrimination laws. If not, the person is, think of it as a secular employee for which the protections apply. And the court said that it's courts decide that issue because it's a legal question about legal rights, not a theological one. It doesn't matter who you think of as your ministers for religious purposes. What matters is what they do and how that maps onto these legal rights. Now, I think it's easy to get into my own view of the case. It's easy to understand why religious institutions should be free to make religious determinations about who will preach, who will teach the faith. I think it's harder to understand why they should also have the same privilege when it comes to entirely non-religious decisions. You're too old, or you have breast cancer, or you're Black, and we just don't want you around. I also worry that the court's decision in these cases leaves it all pretty vague about which employees count legally as ministers. The court said, look at what they do, but didn't tell us much about how to make sense of that. And in fact, the court made a big deal about how religious schools trust teachers, here's what it said, with the responsibility of educating and forming students in the faith. Sure, absolutely. But the court didn't actually pay a lot of attention to what these teachers did, even though that's supposed to be the legal test. As Justice Sotomayor explained in a dissenting opinion, take math teachers, computer teachers, teachers who just read lessons out of a workbook. They don't look like clergy. They don't do the things that we think of this doctrine as protecting. But it may well be that now hundreds of thousands of them at religious schools nationwide might have no legal protections in the workplace. And in fact, there are some organizations, some religious right organizations that have been going around advising religious employers, and it's been several years of this now, to give kind of trivial religious responsibilities to all their employees. Have the janitor read a prayer once a month at a staff meeting. Put it in your handbook that you're all part of our religious mission. And in doing so, the idea is this can give you, the employer, a basis to say later on, if they sue for, race or sex or disability discrimination or religious discrimination, this person is a minister, so no protections. As an employer, you've got nothing to lose in doing that. And I want to give you one more thing and then turn it over to Walter. You may have heard of the Supreme Court's decision in the Hobby Lobby case, and this will come up again later on. But in that case, the court recognized that the craft chain store Hobby Lobby has certain religious free exercise rights against its employees based on the beliefs of the owners. And so I wonder how long it is before the Hobby Lobbies of the world say, gee, we're a corporation with a religious mission, so all our sales clerks are our ministers, no protection for against religious discrimination for them. Again, as an employer, why not give that a try? It may fail, it should fail, but there's no harm in trying and treating your employees that way unless or until the courts hold otherwise. Let me stop there and let Walter have a go.
Sure. Richard, after hearing you, I get this bad taste in my mouth about religious institutions. I know you don't intend that necessarily, but that's how it comes across.
I don't.
So I just want to mention a couple things to add some perspective. This is, and let me say, this is a difficult area. Okay, I understand Americans United actually split in the two cases for favor of one teacher and not the other. And I got to say, I am very sympathetic to the arguments that it doesn't make a lot of appealing sense to say you can be fired for any reason that has nothing to do with religion. Now, the context I want to give is that we do have in the law certain kinds of immunity, and this really is an immunity doctrine, because you can't be sued for these claims. We have absolute judicial immunity, which means a judge can rule against you because of your race, because the way you had your hair, because you look guilty. Now, I like to think that most judges wouldn't do that, but they can, and you can't sue them for ruling the wrong way on an allegation that they did it for. But I'll tell you, those suits happen a lot. I see them in unsuccessful cert petitions to the Supreme Court all the time. Conspiracies of judges had it in for me. We do the same thing for prosecutors. They have absolute immunity in their prosecutorial decisions, even if you think they've made a decision because they don't like your religion or they don't like your politics or whatever it is. So what it comes down to is that the courts, to the extent that they're responsible for the formation and creation of these doctrines, are making a judgment. What are areas that we just want to declare to be sacrosanct because we don't want people using allegations to basically leverage a lawsuit out of it. In this case, the teachers said that they were fired for age and for illness, but those are allegations. They have not been established as fact, and they may or may not be true. The interesting thing again is that the schools did not say, well, actually we fired you for religious reasons. They're saying, no, we didn't fire you for disability. We didn't fire you for age. We fired you because we thought you weren't as good a teacher as we thought you were originally when we hired you, or depending on which case it is. So when it comes to these immunity things, what you're really doing is you're setting up a wall around the body or the person, saying we do not want these to be subject to litigation. Now, you don't have to do it that way. There are other ways it could be done. You could say, for example, that if a religious entity asserts in sincerity and in good faith a religious reason for making its decision, that's going to stand and we're not going to question it. That would be not the same thing, because when a school says, well, no, actually we didn't fire her for religious reasons. We fired her because we thought she was incompetent or wasn't working well with the parents, they wouldn't get that protection. The court could have gone that route, but it didn't. It's decided that it wants to provide this more blanket immunity. I think that may be, I referred to earlier about the expanding government reach and the tentacles. It may be that this is the same court member that has just read the federal Title VII employment discrimination rules to cover sexual orientation and transgenderism. It may be that they're saying, we're going to give the government really broad reach in policing non-discrimination, but at the same time, we're going to build a wall around religious bodies so that they aren't put through the ringer over that. I don't know. That's a speculation. But there are a lot of sympathies on both sides in these cases, and it's frankly a hard question. The court has drawn a line. Let me just quote the operative provision. Last thing I'll do from the opinion. The court said, the religious education and formation of students is the very reason for the existence of most private religious schools. and therefore the selection and supervision of the teachers upon whom the schools rely to do this work lie at the core of their mission. Judicial review of the way in which religious schools discharge those responsibilities would undermine the independence of religious institutions in a way that the First Amendment does not tolerate. And let me just say, that's not a conservative argument. This was a 7-2 decision. Two of the justices you would normally consider to be liberal joined it. I think what the court is grappling with is how do we provide this independence protection for religious bodies and yet not go crazy in doing so.
Richard?
So first of all, yes, Walter is absolutely right. I do not mean to be tarring religious institutions. What I mean to be saying is, there, as with all things, there are probably lots and lots of good actors, but also some bad actors. And what's interesting to me about these cases is something that he rightly pointed out. They didn't come up as the teacher saying, you fired me because I have cancer, you fired me because I'm old, and the school's saying, no, we fired you because you're not of our faith, or you weren't doing a good job with the religious instruction. In one case, the explanation that they gave was for the teacher who turned 64. They said, well, you weren't doing the job we wanted you to in implementing the new math curriculum. And the other, they didn't really give any reason at all, but they definitely didn't say it was a religious reason. Now, courts all the time look at those sorts of considerations where an employer says, you were just a lousy employee, so we fired you. And that doesn't present any problems. And it definitely becomes, as Walter said, it definitely becomes a harder question when there is a dispute about whether the reasons for the determination were religious or non-religious. But when they straightforwardly aren't, it's hard to understand, I think, why the courts can't do the same thing that they would do for any other employer, why religious institutions get freedom just because they are religious institutions to do something that we don't allow for anybody else, and that they don't even say they have a religious reason for doing. That's a really, really broad sort of avoidance of liability, of legal responsibility, that I think is hard to make sense. Recognizing that these can be hard cases, and we did. We thought that the case for the teacher with breast cancer winning was pretty darn good, and the case for the teacher who turned 64 was less good because she had some real religious responsibilities. Those are the sorts of determinations, though, that I think courts can make, and I think it will be a peculiar and dangerous thing if we don't let them make it. And I'm not sure that the court gave us good enough signposts to figure out which is which.
So I want to interject a question that I'd like both of you to address, because I want to put this in some context for our audience. I practiced employment litigation for many years as part of my checkered past. And when we talk about an employer saying, well, here's the reason I fired this employee, and the employee says, no, that wasn't the reason was something else. You both know, cases don't get decided on the basis of, well, the employer says X and the employee says Y, so now I'm going to pick which one makes sense. After the initial assertions in a complaint and defenses that are asserted in an answer to the complaint, we then have the extraordinarily mind-numbing, expensive, time-consuming process known as discovery. And discovery is where most of the time and money goes in these lawsuits, and that's the process by which each side gets to discover from the other what their case is all about. What do the documents say? What do the emails say? What do the witnesses say when they're put into depositions? And at the end of all that, then the case gets resolved either on motions or sometimes an actual trial before a judge and a jury. The idea of, on the one hand, Walter, the deference being given to the religious school to say, well, we have a person teaching, we have a teacher teaching religion in some part, therefore deference ought to be paid to what we say was the reason being given and not be subjected to questioning. I think that's, that's the question to throw to you. And the question I throw to Richard, because I want to do it at the same time and then have you both respond. Richard, the question back is, doesn't your perspective mean that religious institutions have to expose themselves to that kind of scrutiny in the discovery process before you get to the end of, okay, are they entitled to the deference that they want for the decision they made? But that part comes after 2 years, 3 years, hundreds of thousands of dollars in attorney's fees. So I want to put it to you both. Walter, how far does the deference go to shield a religious employer from that kind of inquiry? Richard, how far must a religious employer go through that kind of process before it gets to invoke what you might regard as appropriate deference?
Well, I think the court is very aware of the cost of litigation. They've mentioned that in previous cases. And I think that's what lies behind all the immunity doctrines that the court has adopted, including qualified immunity, frankly, for police officers and other government agents. They're trying to minimize the burden of the expense of litigation. What the court did in this case was it said, well, we do this for ministers. Why do we do this for ministers? Your typical clergy or rabbis or imams or whatever. We do it because we don't want the government supervising the hiring and firing practice of something that's so integral to the religious organization's identity and mission. Frankly, it was a hard question whether that should be extended to religion teachers or not, because they are at least partly removed. They're integral to the mission, but as personnel, they're not as full-time as say, clergy. But that's, I think, definitely what was in the court's mind when it was deciding whether it was going to apply immunity or some less test, which would force the churches or schools to go through litigation.
And in answer to the other half of Doug's question, look, it is certainly right that if courts are less deferential, were less deferential to religious institutions in looking to see whether or how, for instance, if they assert a religious reason for firing or refusing to hire somebody, figure out whether that's true or not, that was really the motivating factor. Yes, that can take a long time. What won't happen and shouldn't happen is that the courts shouldn't be asking, what do we think of your religious doctrine? And do we think that you have genuine religious reasons for not wanting to hire or for wanting to fire somebody? Are those good or bad? The courts should never be asking that. And so they don't dig into that. I recognize that that a different rule would mean more litigation digging into why decisions were made, but not completely. And that, the flips, it would still not be treating religious institutions the same way that everybody else does, because I think it's right that that we don't want to be interfering with what is integral to the operation of the religious institution and its conduct of call it the religious business. But a lot of the things that they do aren't that. And it's not so clear to me why those things don't get treated the way that any other business gets treated. And by the way, I say business, but nonprofits, government, everything else, every other employer. I don't mean to be saying churches are just like a for-profit business. They aren't. But I do think that when there are some things that they do, that they should be like my employer and your employer, and some things that they shouldn't be.
All right. On to the third case. And somehow or another, I know Richard and Walter must be smarter than I am, because when we divided up the cases, I wound up agreeing to discuss the third case. And the sad part is I volunteered to do it. It's clearly the most, if you think the first two cases were hard to reduce to bite-sized pieces for a brief discussion tonight. Little Sisters of Saints Peter and Paul Home versus Pennsylvania, well, is even more difficult to condense, but I'll give it my best shot. And this case involves several layers of decisions by executive branch agencies and several lawsuits over a period of years. But I'm going to boil it down in a way that unavoidably does violence to some of the very important procedural nuances of the case. And were Richard or Walter arguing or re-arguing this case before the Supreme Court, they would necessarily be talking about matters beyond what I can summarize for you quickly. So I'm going to try to focus on the big picture because I want to get them both to address what I think is the most important question that's at the heart of the case. So having all agreed we weren't going to use PowerPoint, I concluded in preparing this that, shall we say, we didn't have a prayer of enabling you to follow along without my sharing my screen to show you some basics. All right, Little Sisters of the Poor is described as an international congregation of Roman Catholic women who have operated homes for the elderly poor in the US since 1868. And they have the religious conviction that deliberately avoiding reproduction through medical means is immoral. I'm operating literally in the dark here. I can't see from one slide to the next. All right, under the Affordable Care Act, requires covered employers must provide women with preventive care and screenings without any cost-sharing requirements. There were guidelines promulgated by an agency of the Health and Human Services Department saying that healthcare plans must provide coverage for all FDA-approved contraceptive methods. Now, pay careful attention. Who was not subject to the mandate to provide the contraceptive services coverage? Originally, there were two ways that you were not subject. One is if you were a house of worship, right? And this became known as the church exemption. So houses of worship were automatically exempt from the mandate to provide contraceptive service coverage in your health insurance plan. Automatically exempt. You did not need to do anything to avoid the requirement of the mandate. The other way not to be subject to the mandate originally was to supply what was referred to as a self-certifying accommodation, namely that you certified that you were opposed to providing the contraceptive service, you're a nonprofit, and that you hold yourself out as a religious organization. All right, so to repeat, if you were a church, you're automatically exempt. Other organizations could self-certify. Little Sisters objected, which was not a house of worship, is not a house of worship. Little Sisters objected to having self-certify. And they said, completing the self-certification form would force them to violate their religious beliefs by taking actions that directly cause others to provide contraception or appear to participate in the government's delivery scheme. They said self-certification violated the Religious Freedom Restoration Act. You heard Walter refer to it before in the business known as RFRA. And in relevant part, RFRA says, government may substantially burden a person's exercise of religion only if it demonstrates that doing so is in furtherance of a compelling government interest and is the least restrictive means of furthering that interest. Again, the government can substantially burden a person's exercise of religion if it can show that it's necessary to do that in furtherance of a compelling government interest and it's the least restrictive means of furthering that interest, okay? Then mayhem ensued. There were lawsuits, there was further administrative action. I am doing great violence to the record here, but eventually there was a final rule that said any non-governmental employer can avail itself of the church exemption. Okay? You don't have to be a house of worship to get the church exemption. As a result, now organizations like Little Sisters need not self-certify, right? And as a result, and yet they could be exempt, right? They didn't have to file the self-certification, but they no longer have to provide contraceptive services. Pennsylvania and New Jersey filed suit, and they said that that rule, the final rule, goes beyond what the Religious Freedom Restoration Act allows. In the Supreme Court, by a vote of 7-2, the court ruled essentially in favor of the final rule. But you need to know 5 justices joined in the majority opinion, saying the final rule relieves employers of a substantial burden. They found it was a substantial burden to self-certify. They found no compelling government interest in providing these contraceptive services, which they said could be provided or obtained in other ways. And self-certification was not the least restrictive means of accomplishing this. 2 of those justices in the majority, Alito and Gorsuch, they wrote a concurrence. Let's just say they would have gone even farther beyond the majority opinion. Justices Kagan and Breyer wrote a separate concurrence, agreeing with the result, but on more limited grounds, suggesting that maybe under further analysis, the rule might not be enforceable. The 2 dissenters were Justices Ginsburg and Sotomayor, who said, in essence, self-certification is not a substantial burden on an organization like Little Sisters, and there was a compelling government interest to provide these contraceptive services. We are now in the realm of what is sometimes referred to as complicity-based conscience claims. Namely, in this case, the argument is filling out a self-certification form. By doing that, the organization feels it's complicit in someone else's activity that violates that organization's religious conscience. So with that, I want to focus on the big question, right? If we have an employer like Little Sisters who says, we're not going to include contraceptive services in our health insurance package, and we're not willing to form notifying people that we're not doing that, that would say, and here's how you can get that coverage. So look at what we've got. We have Little Sisters sincerely believing that signing such a form makes it complicit in doing something that it thinks is religiously offensive. And we have women who either won't receive or will have a harder time receiving contraceptive services. So the question I want to put to Walter and to Richard, and Walter will kick it off with you, where does justice lie in this situation?
Well, when I was preparing for this, I hear an echo. I hope that's not coming through.
I think you're fine.
Okay. The phrase that came up in my mind is live by the sword, die by the sword, which in this case is live by the agency, die by the agency. It's important to remember that the Obamacare, the Affordable Care Act, did not resolve this question. It punted it to an agency. What that means is that it can change from administration to administration. The court took advantage of that because if it had been ruling while it was, say, an Obama administration, it would have had to decide whether or not the more narrow exemptions were permissible, were consistent with RFRA. But it didn't have to do that because the Trump administration had already expanded the exemptions. So all it had to say was, is this something that the Trump administration could do versus what it had to do? And there's an area where I would think that there would be broad agreement, namely that certainly the government can go beyond what's required in providing exemptions. Do you have to provide conscientious objection status for soldiers who object to combat? I don't think the court's answered that question, but they said you certainly can. And if you can, you can't exclude people in a way that would, for example, penalize their religious beliefs. So I think on that broad score, this is definitely the right decision because what they're saying is that the government has the capacity to expand exemptions in a way that accommodates the perceived religious objections of the people who are complaining about it.
Richard?
So I want to clarify something at the beginning, and then I will actually sort of take issue with something that Doug described the case and what the holding is. The first thing I think it's really important to know. So Little Sisters, well, two things about them. One is they run nursing homes across the country where they employ thousands and thousands and thousands of people who aren't nuns. They're nurses, they're orderlies, they're desk clerks, they're all kinds of folks like that. And so it's not just about nuns buying and using contraception, as the newspapers sometimes say, but more than that, more importantly, under the law, and without getting into the details of it, the Little Sisters were never subject to any requirement here. It has to do with the kind of insurance plan that they had. So saying that they would have to fill out the form is just not true. They never did to begin with. Their appearance in the case is sort of mysterious, but it was a case, as Doug said, brought by Pennsylvania against the government. The thing that I wanted to take issue with is I think that the court decided something quite limited, and limited maybe in a boring way, which is that the Affordable Care Act, Obamacare, the statute, gave the U.S. Department of Health and Human Services, or three agencies, the ability to specify what coverage is going to be provided under the Affordable Care Act and to give exemptions from it. But it didn't say, the court didn't say whether these particular exemptions are permitted, required, or not. It said you can give exemptions. The agency wasn't wrong to think that it had the authority, subject to all sorts of other legal constraints, including constitutional ones. And this really comes to the point that I want to talk about, which is this. I think that there are two problems with the idea that saying, I don't want to fill out a form and give notice that I want an exemption from the law for religious reasons is a problem. That argument goes something like this. If I, as a religious entity, have to sign this form and tell the government that I'm not going to be providing contraceptive coverage, or not provide some of it, then the government is going to provide that coverage. Or the insurance company is going to provide it a different way. I'm not paying for it. I'm not involved in it, but I see signing the form as triggering the provision of that coverage. It makes me complicit in the sin of people buying or using contraception. Think about what that argument would look like if we were talking about the real and incredibly important also basis to say I have a religious right not to be subject to the draft. I won't, for religious reasons, I won't fight. What do? When you turn 18, you go to the post office and you fill out the same selective service card everybody else does, except you check the box saying I have a religious reason not to fight. And then the government knows that you're not doing it. And yes, if there were a draft, the government would then select somebody else. Does checking that box mean that you're complicit in the sin of fighting in a war that you don't believe in? And if so, do you have a basis not to check that box just because of what the government is going to turn around and do to accomplish its objective, which is to field an army? In every other context, we say, no, that argument isn't right, not because you don't believe it as a religious matter, but because we just sort of can't make sense of that as a legal matter. The government has to be able to accomplish its objectives. That's what's a little funny about the idea here that not that religious institutions shouldn't have to provide contraceptive insurance coverage, but they shouldn't have to tell anybody that they're not providing it. And ultimately, to get to the constitutional thing, and the last thing I will say before stopping rambling is again to get back to what the Establishment Clause of the First Amendment is supposed to do and not do. It's to say that your religious freedom, my religious freedom, that's about the ability to believe or not, to worship or not, to practice our faith or not. but not the right to impose our religious choices on other people, and not to inflict harm on other people because of it. And if an employer gets to say not just, I won't provide or pay for contraceptive coverage, but I will make sure that the government can't provide it another way, so my employees are left without it, then it's leaving people in a position that they're being subjected to the employer's religious beliefs at great harm to them, at great expense. They're not getting health care that they want and need. And that's not what religious freedom is supposed to be, and it's not what's supposed to be constitutionally guaranteed.
Doug, may I weigh in?
Walter, what about that, Walter?
Yeah, you might make 3 points if I could. One, I'll go backwards. The Little Sisters of the Poor weren't blocking anyone's access to contraceptives. What they were doing is, in a sense, it's kind of like the school funding case, right? You can still send your kids to the private school, whether or not, assuming you can come up with the means, whether or not you have the financial assistance of the scholarship. The Little Sisters weren't saying none of our employees can access this. They're saying we don't want our insurance policy to be hijacked to do something that we consider to be immoral. And I think that was a feature of the case that we haven't talked about yet. It's not just that they are triggering the kind of Rube Goldberg set of contraptions that end up providing the thing they object to, but also it's being done through their policy. They presumably would have the alternative of just canceling, I mean, if the Affordable Care Act allows it, canceling out all insurance coverage for their employees, but then that would involve a different harm that they may not want to engage in. I do think that Richard is exactly right, that there has to be a line between what can a believer require the government to do to accommodate his or her beliefs versus the government requiring the believer to do something that violates those beliefs. That can be hard to draw a line. One of the cases in the Supreme Court that was a few years back involved an Indian burial ground. They said it was sacred and the government was going to, I think, build a road through it. And the Supreme Court said, it's not making you do anything that violates your religious beliefs. It's the government doing something that you wish wouldn't happen because of your religious beliefs. If you think it's violating something sacred, but it's the government totally apart from you doing this, and you can't use the free exercise clause to restrict the government that way. In this case, there are probably several other ways that the government can go about providing birth control free for women without commandeering the policy of the employer. And in that regard, last point I want to make is if you're working for a religious employer or a religiously oriented employer, a kosher halal restaurant, you probably should expect that there's going to potentially be some limits on what you're allowed to do as an employee, even if you aren't subscribing to that religion. It's not like it's a shock that the Little Sisters of the Poor are Catholic, and seriously so. But that said, I think that it's important that we, once again, try not to have the all-expanding, this is my theme for all three cases, the all-expanding government tentacles coming in and basically telling you you have to run your program in a way that makes it impossible for you to do so consistent with your faith. Doug?
We've got a few more minutes. Let's a little more back and forth. Richard, do you want to pick up on any of that? And
yeah,
we'd have time for Walter to respond.
Yeah, I'll quickly start by repeating myself that the Little Sisters are never at risk of anything here. They have a different kind of an insurance plan that was never subject to any of these requirements. Setting that aside, the sort of the issue about, so I understand, I certainly understand saying you go to work for a religious employer, you have to have some expectations about that. Turns out though, that that a lot of employees didn't start out that way. You went to work for a public hospital that then, because of a hospital merger, became part of a network of religious hospitals, and suddenly they're imposing on you requirements that you never had any clue, religious requirements that you never had any clue could possibly be at issue. That's a real thing that goes on a huge amount of the time. And the other thing that I guess I would say, and I would focus on, is that I don't think yes, folks, religious employers who are challenging the requirement say that their insurance plan is being hijacked. That's sort of nice sounding language. I also think that's not true. What we happen to be litigating a case on these same issues and very much like this. And what religious, the way this often works, and I think normally works, is you, as the religious employer, if you're doing what you're supposed to under the law before the new Trump administration regulations, you would sign the form saying we're not providing the coverage. And then the government separately arranges with the insurance company to provide it. The employees got these separate insurance cards to use for the separate coverage and all of that. And it wasn't the case that everything is being thrown together, nor, more importantly, is it the case that that the religious entity was ever being made to pay for anything here. It was, this is the mechanism that the government decided was the best way to get everybody coverage that is for what the government determined to be necessary healthcare, and I think was right about that. And so it is the case that when the employer says, I'm not going to give the government notice so the government can't make other arrangements to provide the care, that really is kind of blocking my employees, or in the case of a university, my students, from getting the care. And that's what I think they're not supposed to be able to do. They don't have to pay for it, but they shouldn't be able to prevent people from getting the coverage another way.
Let me ask a question that I want to try to kind of capture this before we start to wrap up. How much of this, Walter, is about assuming that the act on the third parties, in this case, women seeking contraceptive services, how much of your argument is based on assuming that most of them are going to be able to get it without much of a to-do? And Richard, the flip side of the question is, how much of this about saying it's not really such a substantial burden, and how do we measure substantial burden when it comes to a matter of conscience, like is asserted by an organization like Little Sisters?
The violation of conscience it stands alone in the sense that the government can marshal all kinds of arguments. I mean, okay, this is going to be an example that's really hot and topical, which is vaccines, right? Suppose you're a parent who has a religious objection to vaccines. Well, the government's going to say, if you don't get your vaccine, you're jeopardizing everybody else, right? And that's a very powerful argument. That has to be weighed in, assuming that you're looking at a pre-exercise or RFRA claim, that's going to be in the balance of whether or not the government is allowed to make you do what you consider to be a violation of your conscience. The government should not be in the position of, I think, second guessing whether it in fact violates your conscience. And that's one of the concerns I have with the arguments underlying the challenges to the exemption, is they're really saying, you know, I'm just not convinced that this does violate the Little Sisters' conscience. And that, I think, is not something that should be within bounds.
All right, but let me get back to the half of the question that I was trying to target for you before I throw it back to Richard for the other part. How much of the argument is based on, as a factual matter, most of these women will be able to get comparable contraceptive coverage in some other way that's not a significant burden on them?
Right. I think that, well, again, this is going to depend on your audience, but I think that's an important consideration for those who have the concern that Justice Ginsburg voiced in the oral argument of this case, where she repeatedly said that the government was tossing to the wind the women's access to birth control. It's important, I think, from a legal matter to recognize that Congress did not authorize birth control coverage. They dodged that question entirely, which is why I say live by the agency, die by the agency. They said provide preventive care, and we're not going to tell you what it is. We're going to let this agency decide. Well, the agency is going to decide based on some decision down the road after the law has been passed And that presumably is going to be subject to change from administration to administration. Supreme Court seized on that to say, well, you know, that doesn't look very compelling if you're saying we're going to let it be decided by an agency on a temporary, you know, indefinite maybe, but a temporary basis. How can you say this is an urgent thing we have to get done, but we're not going to say that it has to get done?
So Richard, I suspect there's a chunk there that you'd like to take one more swing at, but I want to try to focus you on the other piece of the question, which is, for your position, how much of this is saying, well, it may be a burden on organizations like Little Sisters, but it's not a substantial burden? How do we sort that out from your perspective?
So look, in the first instance, Walter is absolutely right. It is no place of the courts or the government to be questioning and saying, is your religious belief good or bad or right or wrong? The government can ask, is it sincere? Do you really mean what you're saying? Or are you just claiming that something is religious to get out of a legal requirement? But assuming that it's sincere, you actually mean it and believe it. We don't get to say good belief, bad belief. You feel that your religion is burdened, but it isn't really. This term substantial burden, though, is meant to be a legal test that it's funny language, unfortunately, to use, but the idea is something like, is this supposed to be the thing, the sort of thing that limits the government's ability to act or not? Not that we're not taking it seriously, not that we don't, not that we think it's a wrong or silly religious belief that you have, but is it the sort of thing that we take into account? In the first instance, yes, I think that very much matters. I think that before going to the Supreme Court, which has not decided that question, the lower courts overwhelmingly, the lower courts of appeals overwhelmingly, all but one of the 9 that have decided the question, said having to fill out a form to opt out of and say that you're not going to comply with the law, like that selective service, that draft example that I gave, isn't something that we're going to count as a substantial burden, not because you don't believe that it is, not because we think that you shouldn't believe that it is, but because we just sort of, for government to do what it needs to do, we can't take account of that. And I think that that's part of what's going on. And then to get to the other half, if I can, of Doug, your question, to me, it gets back to when you're talking about the harm to third parties. In part, this gets back to, you wanted us to talk about the play in the joints, and it does, is when can government accommodate religious beliefs more than is required by the Constitution? When can government say, we're going to give you a break on a legal requirement because we don't want to impose on you when it would violate, when obeying would violate your religion, even though we could do that. It would be lawful, it would be constitutional to do that, but we don't want to. The limit on that is supposed to be the thing that I guess I've talked about a couple of times, harms to third parties. And I think it matters a huge amount that the way I understand the 2 religion clauses of the First Amendment, the government can't give religious exemptions that allow me to use the law to impose my religious beliefs or other harms on you, because if it does that, if it says all the women who would be getting contraceptive coverage would be getting medical care that they now have to pay for, and that the government has said is really important, that if I can, because of my religious beliefs, prevent them from getting that, what I'm doing is effectively making them subsidize my religious beliefs. And I'm not supposed to be able to do that. It's akin to the problem that I see in the school voucher case.
Except we do that.
Gentlemen.
We do that in other cases. I mean, the conscientious objector who doesn't fight is subjecting someone else to the risk of death in combat. The employee who's fired because the religious employer has an objection to either their religion or their practices, they're losing a job. And the person who claims a Sabbath exemption under the religious accommodation laws, someone else has to take that place. So there are there are third-party harms, if you want to look at it that way, that are going to always come whenever you accommodate someone. The challenge is to find out where we're going to draw the line. How do we balance that against our concern for making sure people don't have to violate their religious beliefs?
There aren't always those harms. Requirements like you can violate you can not comply with a religious dress with a dress code requirement in order to wear a religious headgear or something like that, a kippah or a hijab. Those don't involve any sort of third-party effects, but it's also the case that that the way that the law, I think, rightly deals with things is it says, yeah, we do have to make judgments about how much a third-party effect is too much, and I think that it is a really, really big deal if you're folks like my clients who are students at Notre Dame University and who are being denied all sorts of health coverage because Notre Dame says we're not going to provide what the Affordable Care Act says, and we're not going to do that thing anymore that we once did, fill out the form so that the coverage is provided a different way, that they just don't get the coverage because they cannot, as students, afford it. That's a huge deal, and it's a huge deal when your health and maybe even your life depends on it. That's not a trivial thing. Somewhere in between there is where the line is, but I don't think it should be anywhere close to your health is put in jeopardy. And I think that's what's going on in what's at issue in these cases.
Of course, Notre Dame is a Catholic school.
Sure, absolutely. And that they don't want to provide, okay, no problem. But that they shouldn't, but the question is whether in not providing, they should be able also to effectively prevent the government from providing it. And that's that's the issue. Do they have the ability effectively to keep the coverage and therefore contraception out of the hands of their students because they have a religious belief that people shouldn't be using contraception, as opposed to the university shouldn't have to pay for it because it violates our religious beliefs. I think those are two very different things. One of them is something that the law does and should take account of. One of them is, I think, basically not fair.
We've identified the gist of the distinction.
Sure. I hope so. I hope so.
I don't know about those of you who are joining us online, but I could only sit for another 4 or 5 hours of this. But we at OLLI take seriously when we say we're here for 90 minutes. So let me now wrap this up with a brief sermon whose primary virtue is that it's brief. I said at the outset, strong feelings about these issues come easier than clear and thoughtful analysis. I hope that tonight's discussion has enabled the latter in the interest of formulating the former. Each of our speakers has provided material about these cases and related issues. They are available on OLLI's website as well as on the websites of their respective organizations. OLLI does not pay its speakers or its moderators. If you are so moved by one speaker or the other, or both, I encourage you to show your support for that speaker's organization by finding the donate function on that organization's website. But let me hasten to add, OLLI offers this and many similar programs without charge or sometimes at modest cost. But it doesn't cost nothing to run an organization that continues to sponsor numerous quality classes, lectures, and programs that are a part of the glory of the Berkshires. Please support OLLI financially, become a member, give. If you enjoyed this program, you might also enjoy an upcoming presentation that OLLI has entitled The Consequences of Conservative Courts. It's October 26th at 3:30 p.m. I will not be moderating. Instead, in an uncharacteristic lapse of judgment, OLLI has asked me to speak. And I will express my appreciation at the beginning of that lecture by arguing with the title. That talk is part of an OLLI course, so to attend, you'll need to be a member of OLLI and to sign up either for the course or for an OLLI Flex Pass. I want to close by saying publicly what I have said umpteen times privately to Richard and to Walter. Both of you, thank you. Thank you for your time today, for bringing these issues to public consideration in a thoughtful way, for helping to enlighten all of us on these, which are some of the great issues of our time. And with that, I thank all of you for joining us. See you around campus. Good night.
Thank you, Richard. Thank you, Walter. And big thanks to Doug for organizing and moderating this so well. And thank you to everyone who attended and submitted so many thoughtful questions and comments. We are never able to get through to all of them. So thank you, and we'll see you all again soon. Good night.
Good night, and thanks.